We're live.
All right, Senate Education Committee.
Yeah.
On the 7th, back after a short break. And we are taking up S227 on act relating to creating immigration protocols in Vermont schools. We're looking at a new draft, and we have with us Rick Segal, our legislative counsel, to walk us through the new draft.
Yes, good afternoon. Rick Sable, Office of Legislative Counsel. So, S227, draft 1.3 is what you all have, is that right? Should have 1.3. Okay.
1.3.
So some significant changes from the introduced version, and this is a combination of receiving some advocate testimony, recommendations, and also trying to kind of thread the needle on what you all want. So I'm not sure how close we are, but let's maybe kind of go through and see if there's things you would like additionally changed. So the purpose statement, I generally don't read these. This is plain English, kind of what the purpose of the bill is. So you're all welcome to read this. It's in session law. So if this bill were to pass later on, you can go back and see why did they do this? What was the reason for it? So if you don't like what's said there, you can recommend changes, but it's just speaking of immigration status and educational right for children.
Did we have no purpose section in the bill? Okay,
No, correct. This was an advocate provided most of it, so I did not write it. Okay, on page 2 is where the substantive statutory changes are.
Yep.
So back on page 1, line 18, I didn't see that we changed the name of the bill anywhere. Maybe that's not the right line, but anyway, it used to be immigration protocols. I thought we were all talking about law enforcement protocols.
So it's a good question. And once I go through the bill, we can kind of discuss if that's necessary. It is still immigration related. So the way that we're actually going to get to right now, the first definition on the page 2, the law enforcement officer previously was specifically federal immigration authorities. And you heard testimony from the AG's office and others have said this is maybe not the best idea to specifically target, and I agree, federal government. So in this case, the definition is has the same meaning as a 20 VSA 2351A, and is a very huge list of Vermont police, and it includes all state police, Capitol Police. It's a very, very broad definition. It also includes any officer of a federal law enforcement agency or any person acting on behalf of a local, state, or federal law enforcement agency. So really, most police officers are going to be included in this definition. But then,
if you want to do little kind of stuff, but you have includes twice.
I do blame the editors. That's my part.
Me.
That's why you're the chair. That's right. All right.
You know, if I read these. Yeah, that's good catch. So on line 5, subdivision B, it does not include a school resource officer or a safety officer who's stationed at the school. Testimony you received, you don't want to have those people excluded from their work. Okay, non-public area of the school also was questioned during testimony. It means an area of a school during a school day or school-sponsored activity that normally requires authorization by the school to enter, consistent with section 1484, which is already in statute, and includes any area a school determines to be non-public. So I think with this definition, the previous definition had a list like a gymnasium, playground, etc. The testimony I heard was that's maybe too not clear. A school would maybe not know what you want them to determine non-public. So in this way, each school can determine what it deems, because every school's different, right? A school can determine that we want our football field or we want this part of the school property to be non-public. But the school may disagree, and they may be more narrowly defined in that definition. So,
Yes.
Just to clarify, they're public schools, but yet we can go, it's non-public for the public to come in.
So it's a good question. When you go to a school today, typically it's locked.
Yes.
Right. You have to buzz something to get in. And that's for various reasons. And 1484 requires schools to adopt this type of access visitor policy of how you allow people into the school. It doesn't talk about law enforcement. But the idea here is the schools already have these policies in place of how to let in visitors. So there's already this idea that it's not totally open to the public.
Could that ever be challenged?
Constitutionally, as
Yeah.
far as this is supposed, yeah.
Okay, because you know, it's the public owns the school, yet
Right.
it's no different. A federal, you have an answer for that?
Great.
Well, I didn't want to interrupt you. Keep going.
No, go ahead.
No, I was just gonna say it's, you know, there are different types and levels of public forums. So there, you've got public forums like the sidewalk in front of the State House, and then quasi-public forums, that would be like a courthouse where, you know, you can't just go in and, you know, it's public, but you can't go into the middle of the hearing and, you know, hold up a banner or, you know, start talking to the judge or anything like that. There's rules regarding. You can, but you're gonna get kicked out and you'll be justified in getting kicked out. Military bases also get paid for by the taxpayers, owned by the public, but, you know, good luck with trying to go in and going wherever you want. So depending on the government's interest in prohibiting access to a public area, there are different tiers as to who can do certain things in certain public
And I
areas.
asked him, but you're a lawyer as well. Could this ever be challenged that you're talking down like football field? How can you designate that wide of an area that doesn't have a fence and you just, anybody at any time can walk onto it? And now all of a sudden, is it kind of like the red lines in a federal facility? So you're gonna have to define that to say where it starts, stops.
This isn't legal advice.
No,
You
I'm
could give
just
legal
looking-
advice, but no, you would presumably ask the question of, is there a rational basis for the government to create a non-public area? So, you know, there's different levels of judicial review and scrutiny. So, you know, when it comes to, race and ethnicity, that goes under strict scrutiny, which is the highest. But then, and then an intermediate scrutiny and then rational basis. And rational basis is basically anything that doesn't involve, I might be oversimplifying this, but anything that doesn't involve immutable characteristics. So if, you know, if you've got, well, I guess one way to look at it, I'll rephrase it. It's, you know, looking at the drinking age. You know, does the government have a rational basis for saying that a 21-year-old can consume alcohol? You know, that's consuming alcohol isn't something as immutable as, you know, whether you're from a certain country or not. I don't know if I'm explaining this.
Well, I just that it could, I guess I'll ask lead counsel, because I do understand where you're coming from because they have dealt federal and state. But it could be challenged at some point, not that anybody might not, but it could be challenged because of the work.
I give you a real lawyer answer. You want the real lawyer answer? Well, like anything could be challenged. Right. Anything. I respect Senator Chief did a good job of explaining the scrutiny analysis. It's very, very in the weeds, right? As far as how this all works. My legal opinion is this is not a huge First Amendment issue because schools are already doing this and that's not been challenged. And I think when it comes to security and safety, that's a pretty good reason for the government to do this. Like today, if you challenge 1484, the argument would be safety of the students and the staff, right? And you want some control over these children, who's going to come in, who's seeing them, who's, you know, so that's the other thing is that, yes, it's public. However, the good reason is this.
Yes.
Thank you, sure.
Page 2, line 7 and 8. The phrase during the school day can introduce a concept, sheltering. And that being that at the end of the school day, all the law enforcement officer has to do is pause and wait, and the student will exit at the end of the school day with their, you know, according to this language. I would submit that we strike during the school day, and it has all the intent and purpose for what I think everybody's trying to accomplish.
And so I think that it's a good point. The reason I added that was I remember testimony about one of the schools used during an election as a polling site. or some other non-school activity, right? So I can't think of anything else besides an election. That's why school-sponsored activity is also there in case it's a football game or some kind of athletic event. But it's it's a good point. I don't think it would include after hours. So an officer could, yes, wait.
So here's the hypothetical scenario. Child's in the school. Law enforcement officers are waiting outside the school. The student is in essentially let's call it the sanctuary area for all better purposes. And they're not protected once the school day is over. And that's not what I think we're trying to advocate. If we're trying to establish a sanctuary area, school and school
Essentially, there is. Yeah, so you're suggesting cross out during the school day.
Yeah.
Or school-sponsored activity, right? Just cross out the alt yellow.
Well, school, there is a school. I think it was school sponsored event. Well, I think Rick is thinking that actually might narrow it.
Yeah, if you keep school-sponsored activity, that's problematic, yeah.
Yeah, actually, I was thinking the same thing you did for a minute. I went, no, you're trying to be as broad as possible instead of suggesting.
Is there a way to put an exemption clause when it's being used for polling or a non-school? That, you know,
Yeah.
that way you can have it covered from day to night, except when a public event such as polling or any other, or a craft fair. Well, you know, I don't. That way, why don't we put is exempt?
Do we have to exempt anything? Because what if we remained silent on that? And it was used for polling. It would still be a sexual one. And I think that's our goal. Right. So maybe we just don't say anything.
Okay, but is that just for the children, not if an adult entered that they were heading after an adult? Does that cover them too?
You know what, they can get themselves some other time.
I don't know if it's gonna help conclude the conversation, make it more complicated, but polling places and all educational institutions are going to be, if 209 passes in its current form is signed into law, will prohibit all civil arrests in all polling
Okay,
places.
civil
And
arrests.
all civil arrests are immigration arrests. We just use that language to make it more encompassing, but so immigration arrests and detainments.
Is that true if they know they came across the border undocumented? If you come through a port and overstay, that becomes a civil. If you come across the border undocumented, like walking across through the woods and that, now that is a misdemeanor, not covered by civil.
If there's a warrant for the person's arrest, a judicial warrant, they can go into a place and arrest them. If it's not that, then they can't.
So, and this is all hypothetical, but we do have border schools. This is why I'm asking this. That you have somebody that Border Patrol actually sees cross by near the high school and sees them cross, not going through a point of entry. Races into the school, are they going to be safe? Because now that's a misdemeanor, not.
That's a
Well, how would they get into the school?
If it's only that day, or if it's a football game going on, or,
Yeah.
you know,
There's already, so this bill, and maybe, this bill will explain what happens, but someone entering a school trespassing, that's a separate issue, right? And that could be handled separately.
Okay.
This bill wouldn't stop, and we'll figure that out. It's still a concern of yours.
because we do have a lot of border patrol. And they flood over there quite easily, and it could be during a football game. It could be that, and I'm not just want protection for our kids and families as well, and not get hindered by not allowing our federal law and state law from doing what they have to do in this case, that this could kind of mess it up a little bit. And if everybody here accept me as that, I will, but as you say, won't die on that sword, but I want, being that we live on a border and this is a reality that could happen. You know, I understand down in Burlington and Essex and all, yeah, I get it.
No, I mean, Jill Martin Diaz, who's on the screen, is one of our best immigration attorneys now in the state and has answered lots of people's questions, no judgment. You know, I think they'd be willing to do this.
Well, why don't we have Jill come in? Unmute yourself. Introduce yourself. Kurt?
Thank you, Chair and Senators of the committee. I am Jill Martin Diaz. My pronouns are they, them. I'm the supervising immigration attorney of Vermont Asylum Assistance Project. We're the state's foremost and largest immigration legal service provider. I previously taught immigration law clinically and doctrinally at Vermont Law and Graduate School, and currently lecture on immigration policy and practice at University of Vermont. I appreciate the opportunity to testify today. I apologize for my casual dress. I'm actually out of the office, but when I received the opportunity to testify and offer whatever expertise I can from what we're seeing on the ground and how the law plays out in practice, I just wanted to make myself available because I think this is such an important conversation. Rick, I don't want to, I can kind of chime in specifically on this Fourth Amendment question that the committee is currently chewing on, and then pass it back to you and just remain available to answer any directed questions from the committee, if that helps. Fabulous. So I really understand the senator's concern about, creating state law that might in any way interfere with federal immigration enforcement authority. But my reading of this statute, from my perspective, the statute is a codification of clarifying who has the authority to make decisions on behalf of a school district in interacting with law enforcement during these law enforcement Fourth Amendment protected issues. So the Fourth Amendment of the Constitution protects the citizenry from unreasonable intrusion into privacy. And there's a lot of very fact-specific situations that have never been tested in the courts. The current immigration enforcement climate is raising lots of really specific hypothetical questions like the ones we're considering here. And as Senator Ram Hinsdale referenced, most of the Know Your Rights requests I get from towns, municipalities, nonprofits, government agencies, and private businesses is a what would happen if, and then a very, very fact-specific hypothetical. And unfortunately, lawyers like us, we typically look to past decisions to help predict future outcomes in hypotheticals. And a lot of what the enforcement activity we're seeing nowadays is really uncharted territory. So we don't have so many past experiences to look for. So we can't, to the point that Rick made about, yes, anyone can challenge anything. I mean, that is true. But what I see here is just a clarification that the superintendent and their delegate are the sole people who get to make decisions on behalf of the school district when interacting with law enforcement authority that are attempting to enter either with or without a judicial warrant, as is required by the Fourth Amendment. So there wouldn't, whether or not, if a law enforcement officer shows up with a judicial warrant from a federal court judge that says, yes, they can conduct a search or seizure on the school premises, even in private areas, according to whatever the judge has approved, whether it's to enforce civil immigration law or federal criminal law, to the point about misdemeanor liability for unlawful entry, nothing in this statute limits the ability of the superintendent or their delegate to grant law enforcement access with a judicial warrant. It's simply a safety check because in this current enforcement climate, we are seeing a lot of very recently hired and limited trained federal agents exercising authority to enter places where there has been no judicial oversight, there has been no judicial warrant. And so there is, I don't recognize anything in the current version 1.3 that would limit Customs and Border Protection or the FBI, let's say, their ability to enter a school property with a judicial warrant to execute an arrest for misdemeanor unlawful entry.
Missed my point, I think, though, if it's up on the border, they see the individual cross the border and they say there's a football game going on and they have to want to apprehend it. Will they or will they not be able to do that, being that the act is happening right then?
Well, that would depend on whether, I mean, according to constitutional jurisprudence, that would depend on whether they have probable cause to effectuate an arrest under exigent circumstances, notwithstanding the lack of a judicial warrant. What we actually, I mean, I hear the call of the question. What we actually see as asylum lawyers is that the majority of people who are too low income to arrive by passport and plane ticket to the United States to seek asylum are typically low-income people from contiguous countries. And so the vast majority of asylum seekers who are low-income that we represent at VAP are people who had no other mechanism of becoming present to seek asylum but to cross the border by land. If in the scenario that someone was coming and the FBI or Border Patrol wanted to enforce an arrest and charge misdemeanor liability for unlawful entry, the constitutional law is very well settled that they would need either exigent circumstances to support a finding of probable cause or a judicial warrant signed by a judge. And I think what this statute is saying that in either event, we are endangering our frontline staff and our communities if we're putting that analysis, that case-by-case analysis, in the hands of any person who happens to work for the school district. And instead centralizing that decision-making authority with a few key players who are best placed to have the training to be able to make the right decisions.
Why don't we keep moving? And
Okay. So the definition of school, small change, adding school resource and safety officers to the definition. And I do want to highlight there's no change here, but some of the comments have been including employees as far as the obligation. School includes employees. So when you see the word school in the bill, it does also include employees, and now making sure to include school resource and safety officers as far as the obligations of what the school must do. So I may highlight those as we go on, but subsection B, this is the policy that's required. There was testimony from the committee requesting that the policy be reviewed at least once every 2 years. So that language was added. And also advocates asked for the Vermont Superintendents Association and the Vermont School Boards Association to be involved in the development of these procedures based on the policy. I think there was the testimony, there's a lack of understanding as to how we actually effectuate these policies. So these two entities would help the schools figure out, here's the policy, here's how you actually act it out. On page 3, not too many changes. This is the immigration resources subsection C, clarifying that when you hand out these resources, that each school designates at least one individual. The previous bill said draft said officer, and there was a request that's confusing. It's not law enforcement, it should just be an individual who serves as a resource for immigration related matters. And again, clarifying that this information is provided by the AG. That wasn't clarified before, so I think the superintendents want to make sure that they're not making this themselves, but they're getting help from the AG's office on those resources, and when they get updated, they get updates from the AG. Subsection D, guardian detainment. The previous draft did not have the words or immigration, as they've now been added. So a superintendent or their designee can partner with a legal or immigration advocacy institution. No other changes to that paragraph. B, student records. The previous draft had school districts. Now it just says schools because we don't have school district defined in this bill. So the request was to make it clear that every school must have these policies or procedures, or at least are prohibited from using these policies and procedures to engage in the following practices. On page 4, subdivision A is added. So kind of going back to the info language, a school is prohibited from using policies or procedures to engage in practices that have the effect of excluding a legal pupil from school, including designated immigration status, citizenship, place of birth, nationality, or national origin, A, in any database that the school maintains. And then the previous language, the director information remains in the bill. Again, that's to avoid some other maybe non-required database that a school may use to store student data. So ensuring that information is not on those databases either. Maybe an informal student directory, that kind of thing. Subsection F, law enforcement on site and requests for information. So several changes here, a lot of it's repeated, and I'll explain why. The superintendent of the school shall be the sole authority to admit a law enforcement officer who appears on an immigration related matter. Now remember, law enforcement officer now means every law enforcement, state, local, federal, but it is narrowed by that immigration related matter, which is defined here in a second. So B, designate at least one individual. The word was just one, so now we're saying at least they can do more than one if they want. At least one who works at each school to serve as designate, who's not present when the change here is this was previously Federal Immigration Authority, now it's law enforcement officer. On page 5, the superintendent or designee shall not allow, again, previously it was a Federal Immigration Authority, now it is a law enforcement officer appearing on an immigration related matter into a non-public area of the school unless a judicial warrant is presented by the officer that names a specific individual under arrest or subject to a search. In the event, again, was Federal Immigration Authority, now law enforcement officer appearing on an immigration related matter, enters a non-public area of school without approval from the superintendent or designee, the school shall not obstruct the officer from entering the non-public area. Absent a judicial warrant, no school shall reveal any information about a student or school staff member in response to an immigration related request from a law enforcement officer. So subdivision 5 is very, very important. This is how you define an immigration related matter or request. It means an administrative warrant, civil warrant, immigration detainment, or any other document or request that pertains to an individual's immigration or citizenship status. So what this means is if a police officer, we talked last time about hearing a gunshot or a phone call 911 about an emergency, that police officer, federal, state, local, they're not appearing on an immigration related matter. They're appearing on some other matter, criminal. It could also be civil, but that would remove that exigent circumstance from basically becoming a problem with the school. In this case, it's very narrowly drawn to apply just to immigration requests, but it also applies to every law enforcement officer. Curious if that threads the needle of what the committee was thinking about.
Jill.
Yeah,
Yeah.
I had specifically flagged for Jill the question about how you need to frame the connection to legal resources.
Yeah, feel free to. Do you want to add something here?
Which section are we?
We're on section 5, we're 112 of page 5. Yeah, Phil, can you hear us?
Yes, there it's a little bit yeah, the sound is a little echoey, but I'm listening very carefully. So I understand that we're moving to the provision on page 5 um at subsection 3.
No, I think it's, subsection 5. Um, we're looking at the section, that defines immigration related matter.
Yes, I mean my reading I thought about, I tried to play scenarios when I was reviewing subsection 5 and imagine if there's any types of documentation, other documents that are not included in this non-exhaustive list that would be excluded. Particularly, the question was raised with BAP about whether this would limit the ability to effectuate a judicial standby guardianship order from the probate division. And I don't believe so, because if if a if a probate division has ordered temporary standby guardianship, and that guardianship triggers at the time of the parent or guardian's detainment, then presumably it would be the standby guardian who would be the person appearing at the school to request information about the child or pick the child up from school, right? The only scenarios that I mean, I'm not as familiar with our child welfare system, like how law enforcement interacts with DCF activity in Vermont, but I can't imagine that there would be law enforcement involvement in a standby guardian's effectuation of the standby guardianship. Like, the standby guardian now has the judicial order clarifying that they are the standby guardian, and then they would presumably call the school to communicate about the child. But I don't know if there was if an issue was raised, or if maybe I'm not understanding the question.
I think there are two separate sections that we're now talking about.
You were asking about the guardian
Right.
advocacy
So
partnership.
yeah, on page 3, the original piece was to look at the language to make sure that we're directing superintendents in the right direction to help a student understand their rights and create a standby guardianship. And then subsection 5 on page 5 is broader than that. It's not just about standby guardianship. Does that?
Well, I think so. So on page 3, subsection D, right, the guardian payment. This is just a procedural thing, and it's optional. It's just to the greatest extent practical. So if a superintendent designee wants to, can partner with some type of legal or immigration advocacy institution, they should. That provides assistance. That's kind of outside the scope of the law enforcement peers, right? This is when you have law enforcement at school trying to get a student or information about a student. That would be, I think they're two separate things, but I want to make sure that the committee understands.
Yes.
So Joe, yeah, go ahead, Joe.
Yeah, thank you for clarifying that we were jumping back. So I'm on page 3 and looking at the provision. What I would note about the way that subsection D is currently worded is that depending on the program, the legal or immigration advocacy program, the service or the duties of the legal workers, the attorneys providing the legal service, the duties might be oriented to either the student or the student's parents or guardians at risk of detainment. And so a more inclusive way to describe subsection D might be to, if the committee was interested and amenable to introduce, provide assistance to a student and or their guardian. Because from our institutional perspective, there are many more legal workers in Vermont who are available to provide service oriented toward a parent who's concerned about their child's welfare in the event of their detainment, rather than child attorneys. But otherwise, I find that having the inclusive or partner with a legal or immigration advocacy institution that would support that that broader definition, because there are many paralegal advocacy organizations that have the technical expertise needed to help families plan. And I think it's prudent in a resource constrained environment to give schools the option of seeking out their assistance from legal or paralegal providers.
Rick, does that make sense to you?
Yep, happy to make that change if the committee wants, adding that. I think the only thing I would remind you about is shall provide assistance to a student or to the student's guardian, however you want to word that. The guardian's been detained by immigration authorities. That's a much more legal hurdle as far as representation. We're not saying representation, it's assistance. So I want to make sure we're clear about that. I think maybe just something to think about as to how much that expands that responsibility of the legal advocate. It's a hard word for me to say, advocacy institution. If that's a much bigger responsibility, if that makes sense. The student is one thing. The student is guardianless, right? They don't have someone to take care of them at that point. I think that's the situation that this paragraph is meant to respond to, but adding the guardian, I think is reasonable. However, is that something that most of these institutions can do?
And
May I ask a clarifying question?
Let's play it out. Let's play it out, Senator. So, Phil, if you were, my question would be: isn't it more? We're not directing that they have to. It's more of an option.
Yes, and I'm glad that Rick just named that, because on first read, I received version 1.3 very close in time to the hearing. So I apologize I didn't lead with this question, but I was not clear whether subsection D was an affirmative authority, an optional encouragement of schools to proactively assist students whose family situation means they are at risk of experiencing guardian detainment, to proactively put into place a standby guardianship plan, because that happens before anyone's been detained. So to the process of creating a standby guardianship is that the guardian at risk of detainment, the subject child, and the proposed standby guardian get together with legal assistance providers in moments of calm and proactively put into place a plan that would only trigger in the event of the guardian's detainment. But it was interesting because when I first read subsection D, I also wasn't clear on whether that temporal, like imploring the schools that this would be helpful in advance. Once a detainment's already happened, then I agree. The only person left to help is the student.
Okay, so I think the way we had, just to play this out, the way I had interpreted it was we were looking at after the fact, and then it would be just the student. You're raising a different possibility.
Yeah, and
But we dealt with that with the bill last year.
the standby guardianships.
Yes, and by guardianships. So,
Well,
and this is about having this is basically knowing who to call.
This is like social service. This is not legal. This
Yeah.
is something's happened to the student's guardian and they need help.
Need help.
Yes.
I mean, what's in my mind, and Jill can confirm or deny this, but very early in the unfolding of this policy, there were students at CVU who essentially received a letter saying, you need to self-deport or we will come to school and get you. And my recollection is lamenting with VAP and Jill that was a very scary letter, but no one ever put them in touch with an attorney to talk about the validity of that letter and their options. And I'm not blaming the school district. They just it was really early and we weren't broadcasting this all over the place that there is legal help. So they self-deported. I mean, they had a goodbye party at the school and they self-deported. So like, maybe I was reading the language and had separated it mentally from guardian detainment, that maybe we could just make sure superintendents have made themselves fully connected to or aware of immigration and legal advocacy services to connect their students when they have a communication that's.
I think it's asking a lot of your superintendents, maybe if they had just mentioned to an advocacy, but have that, all that knowledge, just say, hey, we have the VAAP that,
I mean, if
direct us.
perhaps we can, it says to the greatest extent possible, and perhaps whatever we can direct them to do the greatest extent possible, it could be broader than guardianship matters, just because I know that superintendent was spending a lot of time on this question, just not within maybe their own internal counsel, but not with an immigration attorney, because they didn't know that was available.
They didn't
And
have
did it-
policy.
Yeah,
They didn't know about the VA.
yeah.
We're making that policy.
Well, there you go. But to have them give counsel or even recommend, say, no, I understand you're having an issue. Here's some organizations you
Right.
should reach out to.
So no, this is the part, to the greatest extent possible, partner with, provide assistance to a student, but maybe not make it narrowly focused on around guardianship, but a student that is concerned, I don't know how to frame it, but like is in any kind of immigration crisis, their parents or themselves.
Senator Ram Hinsdale, thank you so much for clarifying. And yes, that is exactly how that CVU example went last year. And I agree that then one, like a simplified fix might be to include, if that the institution will provide assistance to a student in the event that they or their guardian might become detained by immigration authorities, that they or their guardian. And it's just a matter of recognizing that, like, while I recognize that the statute specifically calls on the school not to affirmatively collect unnecessary private information, that could have the effect of excluding kids' access to school. If a young person were to share with school, as the two young girls did at CVU, hey, I got this letter, that then there is this, invitation, this encouragement from the legislature that the school reach out to appropriate legal counsel to be able to provide very technical advice on what their options are. Because it's true that those two young people had legal claims that they were not aware of before they self-deported.
Yes.
This is all great to hear. Subsection C does have, this is the immigration resource subsection where the AG's office gives the schools material. Maybe these things can work together. Hopefully the AG's office has resources to come up with a good resource packet or website for schools to use. So I can see subsection C kind of helping bridge that gap between a student getting a letter and a parent being detained or deported. So in all ways, I think C helps maybe get a better D, as far as you want that to be more, not just being detained, but also immigration questions that students may have, either a letter or something else that they receive.
So can you take a stab at that?
Yeah.
Okay.
Chair, may I ask a question about subsection C1 while we're on it?
Sure.
I was just
Actually,
forecasting.
Where are we?
Page 3,
Page 3, okay.
11.
Yes, thank you.
Yes.
I was forecasting, passing this statute and hoping to not have to take up the committee's time in seeking any further checks and balances on it for community safety purposes. It struck me in subsection C1 that the Office of the Attorney General is a politically elected position, and that the perspective of the Attorney General could swing greatly based on their politics and their policy agenda. And it occurs to me that the Vermont Human Rights Commission is an appointed rather than elected position that's embedded in the executive. So it tends to be less politicized and more stable, and that the Vermont Human Rights Commission attorneys might provide a checks and balances complement to the office of the AG, such that, and again, Attorney General Clark's office has been very cooperative with ensuring the privacy and safety rights of our non-citizen community members. But I'm just forecasting into the future. I wonder if the committee, it struck me that there wasn't a counterbalance, that the superintendent was not dually consulting both the more politicized office of Attorney General as well as the apolitical executive embedded Vermont Human Rights Commission.
Yeah, good, very much.
They want-
They're in here all the time.
Yeah, they want,
Um,
not
okay.
necessarily on
Yeah.
this, they just talk.
Is this still big for her?
Yeah, bigger.
So what exactly are you
Just
suggesting?
adding,
That we add them as somebody with whom the Attorney General will consult?
To the superintendent by the Office of the Attorney General and the Human Rights Commission.
Okay, we can try that. Okay, good. Sorry.
So under 1 and 2, C1 and C, I guess my using the word consulting can be meaningless.
Yeah.
Just give you full disclosure, right? We have several statutes where that phrase is used, and the concern is a politicized AG's office, which could very well happen. Why would they not just say, "Oh, we sent an email," and they don't?
Yeah,
Yeah.
I think, I mean, they're gonna be appointed, they're gonna be elected. I'd rather have it be the elected person. And if we elect the wrong person, well, that's our problem.
It's still swear to uphold the Constitution of the state.
Yeah,
yes,
I don't mind consulting. I mean, and I realize, by the way, every time we say consulting with, it could be a 1 60-second phone call. They consulting, but,
It's just service.
I'd rather have it be I don't mind having it in there, but I just think that if we have to choose which entity is really gonna be responsible, I actually think it should be elected. Since the people.
Well, I guess the question is, does the Office of the Attorney General, are they gonna have updated immigration information for
Or
school?
that the superintendent, you're just looking for the best subject matter expert.
Maybe it's AOE was the last group that communicated with schools about immigration changes.
AOE is going to seek a resource. Same question. Attorney General's office, is going to job.
I'd love for them to have a regular bulletin about immigration related matters. I just don't know if that's,
Well, a regular bulletin versus the opportunity to be a reference. It's two different worlds.
well, it says they're gonna receive on an ongoing basis from the superintendent, updated information and training material as provided to the superintendent by the Office of the Attorney General. I don't know how often the Office of the Attorney General is communicating. with the
Or by
superintendent.
another source.
Yeah, that's also an important note on it.
That has had its resources reviewed and approved by the office.
Lines 4 and 5.
Okay, so we're just charging the Office of the Attorney General with a new thing, which is to talk to superintendents and give them whatever vetted information is the most updated on immigration.
Or by another source that approved by the, so. Jill, just remind us exactly what are you suggesting?
I might suggest that in subsection C1, after by the Attorney General and the Vermont Human Rights Commission, or by another source that has had its resources reviewed and approved by both the AG and the Human Rights Commission, because the Human Rights Commission, right now we're all very collegial, and both offices collaborate regularly with VAP for immigration technical expertise. But I imagine that's situational, not enshrined.
So does the and mean twice? Or does it mean they have to do it together?
If you, I mean, I would defer to Counselor Siegel, but I believe that if you required them, the superintendent to consult, it would be consult both the AG and the Human Rights Commission,
And then what would
or
you
in
do
the
if
alternative,
conflict?
someone else.
There shouldn't be a conflict.
There shouldn't be, but what
But-
if it is?
Well,
Should we ask one of them?
yes, but we're trying to sort out what structure we're.
Yeah.
So I think this will need to be cleaned up. We can't fit, so the word provided is important, so you are being provided this.
Yeah.
This resource by two entities doesn't make much sense. So you would need to say AG, there needs to be one entity that's in charge. Either it's the AG, it's the Human Rights Commission, AOE, whoever it is, that they're in charge. And they consult with either the AG or Human Rights. That's how I would suggest you all structure it.
I'll just put a stake around. I think it should be the AG. Does anybody else have?
I mean, I'm on the Human Rights Commission website only because I think they tend to issue, they're looking into civil rights matters at schools. They tend to already be working with schools pretty regularly. The AG doesn't usually have a direct channel of communication with superintendents.
And so if it's a federal immigration action, I'll bet you the AG would want to be there. So keep it simple. And then they would have aspects they could bring into it. Civil Rights Commissioner that they work with all the time. Does that make sense? Yeah, it's gonna be a dog pile, but they should be in charge. Superintendent needs to know we're setting policy for what they should do. So.
I think the AG makes sense.
Okay.
And the AG will likely rely on the human rights, but put in statute, that's even better. Like, hey, you need to talk to these people. And they may have information you don't know about. And they collaborate and collate it and they give it to the superintendents.
Let's do it that way.
So I'll add in consultation with the
Yeah.
Human Rights Commission. Okay,
Yeah.
I'll work on that. I believe at 3, so I will, I have doctor's appointment. I can maybe stay till 3:05, but
Well, let's we were on page 5.
yeah, we're almost done. So the subsection G, after the definition of immigration related matter at the bottom, adding the word state law. Again, this mostly apply to federal agencies, so adding state and then clarifying. On page 6, this is again a agent's office request that nothing in the section violates federal law, specifically USC 1373 and 1644. This is the federal law that requires information sharing with the federal government. Julio Thompson, I think, testified to that. These are 2 statutes he requested to be mentioned as not being affected by this bill. Subsection I. So this is the model policy that we all discussed last time. I had help from Beth St. James drafting this language. This came a lot of it from the cell phone policy you all passed last year. So very similar language. January, on or before January 1st, 2027. The AOE, in consultation with the Office of the AG, shall develop and review at least annually a model policy that reflects the requirements set forth in subsection B, which is the policy required section, and includes the following provisions. See, I left that open.
On that, should we put up on line 6, the Attorney General in consults with,
So
that we're getting.
it's a policy. AOE tends to set model policy
Right.
for schools, so I don't.
I just want to,
I had
Protecting your
I had the same thought,
Yeah.
but I think I understand why it's the way it is.
okay,
That's
fine.
Yeah.
The immigration stuff is so specific to the AG's office. I think that's kind of a sub problem that the AG is better off to have, but the entire policy, I think, in consultation with the AG makes sense. But again, it's your choice, obviously. So the provisions we can talk about later. If you want to include certain things, you don't have to, but I put that there in case you want to. The adoption, this should look very familiar, beginning with the 2027-2028 school year. Each school board is develop, adopt, ensure the enforcement of, and make available in the manner described in 5631 of this title, and immigration protocol policy that should be at least as stringent as the model policy developed by the agency and subdivision 1. A school board that fails to adopt a policy shall be presumed to have adopted the most current model policy published by the agency. Beginning, and this is the same language except for independent schools, subdivision B. On the last page, excuse me, section 3, this is the guide that the AG produces in consultation with the AG, with AOE. The only change are the date being pushed back to August 1, for the guide completion, and then sent to superintendents on or before August 31.
Did we check with the AG to make sure that
I
this
just
one's
Texted Julio.
okay? So you don't wanna,
Yeah,
he's like, well, October would work better. It'd be-
I mean, I just texted it with
Okay.
the whole concept, just to make sure they.
So you send it over around Tuesday, and you want to think about over the week we're going on. What we would fill in with work to make sure what we might fill in on line 10.
The TBD part.
Yeah,
And
that's just to give us something to.
it's sort of like the bulleted list of things that would have to be in a model policy for it
Yeah.
to be comprehensive enough.
And
So Jill, you can help with that. Yeah. And
so one note, the that last section, that is cross-referencing C1 that we just talked about with the Human Rights Commission. So I'll need to update that link to ensure they're consulted in creating that guide, because it's due by a certain time. So
Right.
I will update those.
Do you wanna be on a thread with me and Jill to talk about the elements of a
That's fine.
model policy?
I'll be out until next Thursday, but I'll at that point.
You know what? That's fine with me also.
But yeah, good copy making. That way I can come back and I can see everything.
Yeah.
Yes.
good, so you've got a couple things you're gonna work on.
Yes.
And we'll plan to have you back in on Tuesday. And
Sounds good.
Jill, thank you. That was helpful for, and thanks for your help
Many
over
ways
the
this
week.
is not good.
You want to see family on this vacation?
We have about, in case any last questions for Jill? Okay, thank you.
Thank you all. Have a good time. Any breaks?
Thanks.
Thank you very much, the committee.
Thank you.
Get myself here.
For the week, we are still live and we're joined by Dr. Henderson, and we are now shifting gears to S232, an act related to public libraries and the Department of Libraries.
Good afternoon.
And I'll just start off by saying that if I'm reading the committee right, Tucker had given us two versions. If I'm reading the committee right, we are dealing with the one that inserts 5%. Yep.
Yes.
And we're good. I think final walkthrough and possible vote. So, Tucker, you are on.
All right, good afternoon, Tucker Anderson, Legislative Council. You have in front of you draft 3.1 of the committee's amendment to S232. Start on page 1, section 1 contains the findings. That's all that I have to cover with you. Don't want to read that. I typically do not. They are your legislative findings. I have nothing to add or alter about your investigations. So fine. Okay. Section 2 establishes Vermont Libraries Day as the third Monday in the month of October. Section 3, section that was just discussed, dealing with the Universal After School and Summer Special Fund. The proposed amendment amend subdivision A1 to establish grant programs managed by the Agency of Education and the Department of Libraries. Then goes on, page 3. First, to specify that 95% of the cannabis sales tax revenue deposited in the special fund is to be used by the Agency of Education. And then it has the current program language. Subdivision 2, 5% of that tax revenue is deposited in the fund to be used by the Department of Libraries to support after school and summer programming specifically at libraries. Now, that use of libraries is broad. One of the questions that came up last time, and certainly a quick amendment, is whether that should be public libraries, not defined for purposes of this title, but elsewhere is defined to incorporate all libraries that are open to the public.
So that would rewind it to that best. If we use just the term libraries, and then there is such a thing as this, would a private library be a 501c3?
Yes,
Well, want to put that. So the term libraries works.
it's the broadest possible use of the term.
Yeah.
I believe the concern that was discussed last time is whether this would extend to, for example, school libraries, but school libraries are not independently organized. They're part of the school.
Yeah.
Those are the substantive amendments in that section. Right at the end, in subsection B on page 4, the state librarian is added as a member of the advisory committee that oversees the use of the fund. In this section,
So we go back to that definition of libraries, does that include like post-secondary school libraries?
assuming that they are independently organized, yes, it would include that in libraries. Section 4 amends some of the early education language. This is around funds for voluntary early education programs. And this allows, amended subsection A, for those funds to be used for training for public library staff within this program. Subsection B, public libraries are specifically called out as eligible for receiving some of these funds. As was previously discussed, this is a specific call out. It's not legally necessary because the library is already qualified. It's just flagging that they are.
Because, just going back to section 3, just for a second, do we need to put any kind of report back mechanism here for how the library commissioner is using these things? Anything? I don't know if the library commissioner does an annual report, but how they exercise this, these funds might be of interest, at least for this purposes.
Well, we have to go, we
I
do it.
I thought they have a certain guideline in that, grant that they're gonna follow.
We're not just giving them money.
Yeah,
That's AOE.
yeah, that's
Now 5% goes in
that's
the liquor.
5%. So we could, I mean, the other thing is having the committee. We do that, we do that, we do.
So that everybody has full visibility.
Should be glad to report back.
It should be this. We need formal, right?
Okay.
Tucker, we had a concern that people were saying, wow, you're gonna open the floodgates, because you're allowing, the Department of Libraries to dip their fingers into this now. Is there other agencies that have, that you know of, I should say, that have actors, in programs that could start knocking on the door for a piece of the pie? Or it's pretty much AOE and libraries, because if it's not a state agency, we wouldn't even entertain it.
The list of eligible recipients is fairly long, as you may recall from discussing some of this. And I'm not aware of other agencies that would come in, but if they did, this doesn't establish some sort of binding precedent for the General Assembly to entertain those requests. You're making a specific policy choice within the four corners of this bill. Anyone in the world could come forward to ask for specific appropriations from this one. It is up to your wisdom to entertain those requests.
I don't have to.
So nothing inhibits them from continuing to apply from AOE, for example, Boys and Girls. There's a whole list of firsts, so they're not really AOE, they're not supervised by the AOE with the exception of these grant funds. Science museum was so rather broad.
The Boys and Girls Scouts are get grants.
I know, I'm reading off the list of, awardees already,
Right.
so nothing prevents them.
Yes.
I recall at one point, we were then discussing if we need to, if we need to ensure that like school libraries are still eligible for the 95%.
Yes,
Is that written in here?
doesn't have to be.
It doesn't? Okay. I mean, so we're basically, the Department of Libraries already has a channel where they set an equal, I don't know if it's proportional, but just kind of equal amount of money to each library that does after school. That's like $300.
$350.
And everyone's envisioning that they send a relatively equal amount of money to the same groups.
Not necessarily. I think
Okay.
this could be a grant
They
program,
still have to ask.
but it would be
Okay.
a much simpler grant program
Okay.
that the one department
So
gets.
we're really leaving it up to them.
Yeah.
And
That gets to Senator Weeks' budget, for,
right. And then even a public library could still be part of an application for the larger funds.
they wanted to do the bigger application that we
The whole reason for this
looked at
was
yesterday.
that the libraries don't need as much money and going through the application process. So arduous that they wanted to be able to, like Chittenden County Library might need $10,000, where to go down to a single room library. Hey, if we got $2,000, we feel like for our summer program would be. And that just makes it, we're giving them a vehicle to make it easier to disperse their money between the libraries.
But I think the answer is we're not prohibiting anybody who otherwise could have.
Mhm.
It's just the pot is slightly smaller. It's not 95%. So did you want to pursue your point 4 to watch whether on the report back?
I don't know, everybody seemed comfortable. I just want to make sure Commissioner understands that we get this pot of money that scrutiny comes with it. We're not going to formalize it.
I believe she said they already have a mechanism that they can show us in that how it looks out. Eventually.
So the reports repeal bill is about to come over to the Senate from the House, and as the drafter for that, I can repeat to you what I repeated through that process, which is they've got varying levels of oversight in the General Assembly. And the most basic form of oversight is that you have the ability to call the head of the agency to testify about the use of funds. You have the ability through multiple mechanisms to request records, to review how the money is being spent, to review the grant program documents. And the reporting requirement you could build into session law or statute here would be a specific request filed automatically and affirmatively by the agency ongoing. But that comes with a determination of value about the information you're receiving. It's a choice.
Where are you ending?
Coleman,
Coleman.
The most simple is something.
Okay,
Simplest perfect.
so now we're on section 5.
We are on section 5. These were the updates within the duties and functions of the department. First, to clarify that these are digital and physical collections that are overseen by the department.
digital, or
That is correct, with the exception of one digital and physical. Is that there was part of the discretionary, I believe. In subdivision 4, the collection may be composed of digital and physical materials. At the end of that same subdivision, the other change committee made in the section was to eliminate the reference to the book wags and to update language around it for library.
wagon.
Gotta keep it.
In section 6, this is the construction language. Construction is a statutory construction to ensure that municipal corporations, by virtue of having an appropriation to a privately incorporated library, do not have the authority to appoint the trustees of that privately incorporated library. This is to correct an interpretation of this section of law. In section 7, these clarifying language around municipal bonds or library infrastructure. Libraries already qualify for municipal bonding support. This was one of those clarified call outs to make sure that the libraries were aware that there's bonding eligibility. Section 8, we're on page 7. We're going to move into page 8 shortly. The next two sections deal with grant programs. First, performance grant programs. They go through RPCs and regional development corporations. As part of the application, you have asked the service providers to address and demonstrate capability and willingness to assist public libraries. So libraries are going to be included in part of the consideration of the eligibility grant. Same in section 9 for municipal bylaw modernization grants. The regional municipal planning commissions, when they apply for these grants, will be required to update the utility and facility element of the municipal plan and address specifically library facilities as part of that. We're on the last page, section 10, repeals the audiovisual revolving fund. From what I understand from the testimony the committee received, this fund is empty and defunct. So it's repealed. Section 11 is the effective date, July 1st, 2026.
So I had never focused on updating the different plans you do in the facility.
I remember I had a concern of
Just, so what's your concern? Start with that.
that we have put additional money into helping municipalities update their plans. It's not an easy thing for small municipalities to do. And I don't think we should add any additional planning requirements to their municipal plans. It usually becomes a deterrent from gathering the resources together to update their municipal plan the more we add. And they need that for our housing.
So.
Yeah.
To receive the grant, no, this is for this, in order to receive a municipal bylaw modernization grant, municipality shall, or it said, add a housing element. And so now we're saying add an element about libraries.
So to be clear, this is an element of the municipal plan that is already required separately in law. But for purposes of accessing this grant program, this amendment would require them to update that component of their municipal plan in order to apply for support under the grant.
So updated just because of so that, why would we do that? Because they don't, the plans get updated on a cycle, 10 years. So we're saying that in order to apply for this grant, you have to update your plan, and that is a fair amount of work. And why are we doing that? That doesn't seem like a good idea to me.
I can't speak to the why, the intent, or the policy. I can tell you that functionally, it is putting libraries in the same position as the other required updated criteria in the plan. So if we were to pull up 24 VSA section 4307, you would see that there's a number of required updates before you can apply for the grant. So in the preceding subdivision, it requires that the municipal plan be updated as to its housing, right? And functionally, this is putting libraries in the same position as those other call outs from the state, saying that when you're updating your plan for purposes of eligibility, you'll also have to update the provisions related to your library.
So it's not like some orders because you're gonna be having to, they're gonna be doing it anyway.
Well, it's another kind of big ask to access the bylaw modernization grant, which we really want towns to access. And we've put, or I don't know if it's written exactly this way here, but we've used this section recently for housing and climate resilience.
Yeah.
So my concern was that we kind of agreed already to put a big burden on them and then add more money to the bylaw modernization grants. This isn't coupled with a larger effort to have their bylaw modernization incentivize certain benefits from the state.
Okay, go ahead.
So I think they're only gonna be required to update or to request this grant every 4 years, right? That was what they said. If, could they update the common plan, just this section of it?
They could do whatever they want. This is if they're gonna get these like $75,000 to $150,000 bylaw modernize, or maybe sometimes less, but
You know, we could almost make the argument, this isn't even our jurisdiction,
I think I said that. I think I said it's like GovOps or
because
something.
this is about municipal bylaw grants, modernization grants, what that doing?
That
Education
GovOps.
committee.
I
I'm
think, yeah,
good striking it out.
Yeah, I think if we wanted to bring this to attention of either the natural resources or the economic development, we need do that, yeah,
yeah.
I mean, I'm not sure how big a deal it is to add it, because we're just talking about,
It's work hours that people
Yeah.
gonna put in.
Yeah, I'm-
That's one and a
I'm
half.
fine, why don't we do that? Why don't we just, so, I say, why don't we, but what, does it make sense to people to just write section 9?
Okay.
I'm fine with that. What about Nate? Bunch of grants.
You're all email.
Um. Yeah, what are the performance grants? What are we talking about there?
These are grants for regional planning commissions and regional development corporations to update those RDC plans. So there's a generic term used so that they can apply either to the regional planning commission or the regional development corporation that is established under that chapter of law. The service provider, which could be either applies for a grant to support the economic development planning for that region. And as part of that, you have a very similar call out that the service provider has to demonstrate a willingness to assist and support libraries and is taking library facilities into consideration with the development of the regional plan.
With the development of the regional, so we're talking about RPCs? So this is so 8 is really the RPC corollary to section 9, which was municipal.
They're actually both regional planning commission related. One is just about regional development corporations, and then the other is a grant program to support updating the municipal plans.
Modernization grants, yeah.
You said they were already required, right? You said they were already required to do this?
So that was when we were talking about the municipal bylaw modernization grants
Right.
and updating the municipal plan. Yes, libraries are already one of the facilities that are.
So do we
being
need to say it again? Here?
This is a call out for those preceding section, regional development corporations and RPCs that are acting as the service provider for updating the regional development plans.
So because we touched on these bylaw modernization grants for the last 3 years in economic development for our housing bills. We took a lot of testimony from Department of Housing and Community Development on how these grants are getting out the door, the many communities that don't have municipal zoning and bylaws because even that is cumbersome for them, and who tends to uptake this. And then we had a rural index that was coming into play for communities that don't have a lot of staff. I wouldn't do this in a vacuum. Like there's a lot of
So I think that's a
problem.
So, so one possibility would be for somebody to make a motion to approve minus sections 8 and 9.
I make a motion that we approve.
If you could have 2 more seconds, I was actively updating a draft 3.2. Well, and I can send it immediately to, yeah.
Then we have repeal of audio visual revolving. Oh, and
Get it
then
out because it's the fun.
Yeah, so it would be to strike sections 8 and 9 and renumber accordingly.
Yep, and it will be draft 3.2, timestamp 2/27/2026, 3:22 PM. And as soon as this saves, I'll send the PDF to the committee.
So I can just say 3.2. And that'll have only one, or do you want to see it first? I move that we approve, Bill S. 232, 3.2.
And I'm gonna add 3.2
Yes,
to
For a section.
yeah. So we have a motion on the table. Discussion.
Just quickly say, this wasn't by design, but it's great that Vermont Libraries Day lands on my birthday. It wasn't intended.
Oh, I should have.
or
Oh, is it coming out?
Okay, now we gotta change it.
Yeah, well, too late for the motion.
This year,
Somebody
it's
else.
always like
Yeah.
the third Monday or.
This year.
Read bookmarks throughout the state, I'll just have your face on.
That's, yes, we should actually.
We could put S slash motion.
Yes.
2026.
Yeah, I think that's nice.
Yeah, okay. So,
Totally.
yeah.
Yeah.
All right.
Good discussion.
Um, Okay, we'll be ready. So the clerk shall call the roll.
Senator Hashim,
Yes.
Senator Hufford,
Yes.
Senator Von Hinsdale,
Yes.
Senator Weeks,
Yes.
Senator Williams, yeah, Senator Bonner.
Yes. I have just asked in a quick side conversation whether Senator Weeks would be willing to report it out. And yes, I think he said yes.
No, I feel like this.
I agree, yes.
Try you first.
They catch it on YouTube.
The buck stops there. Me.
Yeah.
No. I'll take one for the team.
He has enthusiastic volunteer.
Check that out.
So, with
That
that,
out loud here.
very different. Yeah. We are, so, just to recap the video here, we'll have a draft of something but for the larger effort, when we come back on Tuesday. We are having people back on Tuesday 7th on Tuesday with the next that Tucker, thank you very much.
It's always on.
And where did we leave off like over Bill about the Hampshire? We had some.
That they have S6
That's right. That's
capital for a day.
We're gonna get back from there.
Uh-huh.
We're gonna get them in on Tuesday as well. So our Tuesday, we're, looking like we're gonna have full day.
Yep, I just got it,
Okay,
3.2.
with that, we are adjourned.
Good job, Cal.